So I have some huge news for you guys. The state of California's new concealed carry law that they passed in direct defiance to the Supreme Court's Bruen decision was just struck down. So let's talk about this huge win out of California. But real quick before we jump into this video, if you think the state of California needs to stop violating the Second Amendment, go ahead and hit that like button and subscribe. Also, I just want to briefly mention that we do have a podcast available. You can find it using the links down below. And if you search just simply everywhere, Apple Podcasts, Spotify, Google, really anywhere, you can find it. I would love to have your guys' support over there. I'm putting out unique content over there that you can't get over here on YouTube. So if you want to support the podcast, check that out. But regardless, thank you guys so much for all of your support. So as I mentioned in the intro, in this video, I'm going to be talking about a huge win out of California. Now, this video is actually very strange for me to make because it's the first time I'm ever making a video breaking down a case and a decision that I'm directly involved in. The case we're going to be talking about in this video is called Reno May v. Bonta. Yes, that Reno May, the other YouTube guy here in California. Go check out his channel. Myself, CRPA, GOA, Second Amendment Foundation, and then also Gun Owners of California, and a bunch of other individual plaintiffs joined together to sue the state of California because of that new SB 2 law. This SB 2 law is a new restriction on concealed carry in the state of California. Well, yesterday we received a big decision out of Judge Carney in the federal district court. Judge Carmack Carney granted a preliminary injunction against the various aspects of California's new SB 2 CCW restrictions. With the looming SB 2 restrictions going in place at the beginning of next year, this is a huge win. Now, first, I want to give a thanks to CRPA, Gun Owners of California, Gun Owners of America, Second Amendment Foundation, and all the attorneys who actually did the work in this case. If you are in California, I highly recommend that you donate to these organizations, support them. Don't give me thanks, don't give Reno thanks. Give these organizations and these attorneys thanks for getting this win. I will have links down below in the description section where you can also donate and support these organizations. SB 2 was passed in direct defiance to the Supreme Court's recent 6-3 decision in New York State Rifle and Pistol Association versus Bruen. In Bruen, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. Bruen, of course, was a big win for the 2A cause, and it forced an end to May issue CCW licensing schemes. However, states like New York and California decided to directly defy the Supreme Court and pass new concealed carry restrictions that would in practice essentially make it impossible to lawfully carry. SB 2 first enhanced the training requirements in California. It changed the class requirement for new CCW applications from 8 hours of training to 16 hours of training, and then it also changed renewals from 4 hours of training to 8 hours of training. But even before you get that new insane course requirement, before you go through that, your application may still be denied because SB 2 established a determination by law enforcement agencies that people are essentially of good moral character. SB 2 says that issuing agencies can issue permits if the applicant is not a disqualified person. But let's say even if it goes your way, you go through the process, you're not deemed a disqualified person, you do the course, you pay your fees, well, you're good to go, right? Well, no, not under SB 2. Under SB 2, the state added in super restrictive carry locations, essentially making almost the entire state of California a gun-free zone. Essentially, the state of California made a carry permit useless by making almost everywhere a sensitive location. SB 2 has a specific list of sensitive locations, and they have a catch-all provision that makes any private-owned property essentially off limits unless that owner posts a sign which expressly says that it's legal to carry there concealed at that location. So the earnest is on the business to put out a sign saying, yes, you can concealed carry here. It kind of flips the paradigm on its head. So that was the structure of SB 2, and that is what is challenged in this case, May v. Bonta. Now, like I mentioned, Judge Carney granted an injunction against SB 2. Now, for reference, the specific locations that are protected under this injunction are hospitals, public transportation, any place where alcohol is sold, public gathering areas, playgrounds, parks and recs areas, casinos, stadiums, public libraries, amusement parks, zoos and museums, churches, banks, and then finally also just any private property. This injunction stops all of those carry restrictions. Now, in this decision, Judge Carney states that we live in dangerous times. Nearly every day, we are barraged with stories about school shootings, attacks on places of worship, and other unthinkable acts of violence and cruelty. Daily, our country faces prejudice and division of all types, economic uncertainty and poverty, a nationwide mental health crisis, and an epidemic of addiction and crime. The only hope to find in the face of such dire circumstances is that democracy, as it has up to this point, will prevail and somehow solve the challenges we face. But such hope is little comfort to individuals who, through no fault of their own, find themselves beset by an attacker and facing their death or that of their loved ones. The right to self-defense and to defend one's family is fundamental and inherent to our very humanity, irrespective of any formal codification. In their wisdom, the founders recognized the need for individual citizens to protect themselves and their loved ones from those that would do them harm, and they knew that such a right could not be vindicated without the right to bear arms. The Second Amendment to the United States Constitution guarantees law-abiding, responsible citizens the right to keep and bear arms for self-defense in cases of confrontation. For many years, the right to bear arms, and so necessarily the right to self-defense, was relegated to second-class status. But the Supreme Court made clear in their landmark decisions in Heller and Bruin that relegation could no longer be permitted. Individuals must be able to effectuate their right to self-defense by, if they choose, responsibly bearing arms. Some disagree with the founders and the Supreme Court that individual citizens have a right to protect themselves and believe that the best solution to many dangers of the modern day is to prevent law-abiding citizens from carrying handguns. It is not this court's place to question their judgment as to how to solve the many challenges we face. That is up to the people and their elected representatives. But the Constitution, by design, recognizes that some rights are so important and sacrosanct that nothing short of constitutional amendment may take them away. No one, not a federal judge, not a state governor or legislator, not even the President of the United States is above the Constitution. So that is some beautiful language. I get kind of chills reading that. It's an awesome decision. I think a lot of the things that he says really hit home, especially with gun owners. He then goes on to look at the restrictions based on the standards of the preliminary injunction. A preliminary injunction is simply a temporary halt that is put in place until the case is ultimately resolved. So it's a temporary remedy. Now, the main factors to get an injunction like this is showing of a likelihood of success on the merits, that there's irreparable harm absent the injunction, that the balance of equities is in your favor, and that also it's in the public's best interest. And ultimately, Judge Carney ruled in favor of us, the plaintiffs, and issued the preliminary injunction. Now, Judge Carney found and stated that to obtain their CCW permits, plaintiffs demonstrated safe handling of and shooting proficiency with each firearm. They sought to carry, and the plain text of the Second Amendment unquestionably protects plaintiffs' proposed course of conduct of carrying handguns outside the house for self-defense. Because of that, the first textual requirement under Bruin is met. Then he moves on to step 2, which is, can the government justify their restrictions with any evidence dating back to 1791? And Judge Carney finds that they cannot. He goes through each of these specific restrictions, looks at the evidence presented by the state of California and then also in opposition by the attorneys here, and he finds that there is no historical support for these types of limitations. And he concludes his order by stating that the Second Amendment preserves a fundamental constitutional right for law-abiding citizens to keep and bear arms for self-defense. Increasingly, in modern times, with the ubiquity of guns and our country's high level of gun violence, ordinary law-abiding people feel a need to carry handguns in public to protect themselves and their families against violence. CCW permit holders are among the most responsible, reliable, law-abiding citizens. They have been through the vigorous vetting and training process following their application to carry a concealed handgun. The challenged SB 2 provisions unconstitutionally deprive this group of their constitutional right to carry a handgun in public for self-defense. Therefore, those provisions must be preliminarily enjoined. So that there is a huge win in California. We got a huge win against the new California CCW restrictions. These were set to take place at the beginning of next year. A lot of people were concerned about them, and we just got an injunction against these various provisions. Now, of course, Newsom and Rob Bonta have responded by whining, name-calling, attacking this judge, and saying that they are going to appeal up to the Ninth Circuit. Now, we knew they would do that. They always do that. We'll have to see how this develops. The likelihood is, though, in my eyes, that even the Ninth Circuit will not uphold what California is doing. They're going to agree with this lower court here. Because keep in mind, the same thing has happened already in the Second Circuit and the Third Circuit. Even in those liberal circuit courts in the Second Circuit, the laws put in place by New York, the laws put in place by New Jersey in the Third Circuit, they have all been struck down even by those courts. Despite this being appealed, I think this is still going to be very positive, and at least right now we have some sort of protection against this looming SB2 law that's set to take place next year. But as always, if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.